I welcome you back to the next session. We have with us Dr. Akhtar Parvez, the Chief Librarian of Mano. As I had mentioned earlier, he's an extremely experienced person who has worked in very reputed institutes like Indian Institute of Management, uh, interna- uh, uh, International Center at India International Center at Delhi, and so on. So we are very fortunate to have him with us today, and he'll be speaking to us about intellectual property rights. So over to you, Dr. Akhtar Parvez.
Yeah, thank you very much, sir. And once again, I thank you for the invite. And as you had said, I'll be speaking on intellectual property. And basically, I'll be covering copyright and fair use, because this is something which we use every day in our life while we write research papers, or if you want to use some information from some other source. So copyright and fair use is something which we must understand very clearly. So I think I got muted once again. Anyway, so what is intellectual property? Let me just tell you the definition first. Intellectual property refers to creations of mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. And this is the definition which is given by World Intellectual Property Organization. And this definition actually, if you see this definition, it is quite wide. It involves, or it covers almost everything. It also covers, the way today I am delivering this lecture. So the ambit of this definition is quite wide. And intellectual property contains, things like patents, copyright, trademarks, trade secrets, geographical indicators. I'm sure you must have seen uh, uh, what Assam tea, etc. So these are called actually geographical indicators. And IP, or intellectual property, is protected by law. And this is something, which is a state created monopoly. uh, Monopoly is not good for anyone, but this is something which has been created by state. And the reason why it is there, it is basically to protect the interest of creators, and then keeping a necessary balance between the rights or interest of creators and of course the general public good. And this is so important that in Article 27 of Universal Declaration of Human Rights, it was considered like a human right, but not human right per se. So what it says in Article 27, it says everyone has the right to the protection of the moral and material interests resulting from any scientific, literary or artistic production of which he is the author. Okay, so you can imagine, the kind of importance that intellectual property got even at the United Nations. So let me just briefly tell you what patent is. I'm sure you all know it, but still, for the sake of definition, let me describe it in brief. So a patent is an exclusive right granted for an invention. A patent provides patent owners with protection for their inventions. And protection, is generally granted for a period of 20 years in India. And trademark is basically a device which distinctly points to the origin or ownership of merchandise to which it is applied and legally reserved to the exclusive use of the owner as maker or seller. And this is a dictionary, Webster's dictionary has, Merriam-Webster's dictionary has given. So, in this case, what happens that exclusive rights are given. So exclusive rights means only to a particular person or institution or company. So that is called exclusive. These are some of these symbols which probably will be will tell you, what all trademarks are. So like, you recognize these things simply by seeing the product cover, like, Mercedes, or, Colgate, Maruti Suzuki, etc. So these are some of the uh, major, trademarks that we have. And then, the third thing is the trade secrets. So trade secrets may include a formula, compilation, program, device, method, technique, or process. Like we know that Coke is prepared using a particular formula. That formula is not, of course, available to its competitors. And because, if somebody, in fact, these trade secrets provides one company competitive advantage over the other. So that is called trade secret. And the question is, if intellectual property laws were not there, what would have happened? Google is something very wonderful which we all use today. And if there was no protection to the intellectual property of the creators of Google, probably we would not have seen such creation. Now similarly, Google had come out with a driverless car, which has been experimented in one of the states of the United States. And this is another invention. Then we see a lot of apps coming every day. The reason why we write books is, one, of course, we want recognition in our community. And the other is, of course, we expect some kind of revenue from such creations. And that's the incentive that I get from such creations. So hence, it becomes very important that our creations are protected by the government. And these are some of the important IPR laws, starting with the Copyright Act of 1957. Then you have Patents Act, then Trademarks Act, and other kinds of acts which you see on your screen. So as I said, we will be focusing on copyright, and the reason is that we every day, face the copyright issues. We are not sure how a copyrighted material can be used by you or anybody. So copyright laws actually grant authors, artists, performers, producers of music, and other creators protection for their works. And this is given in Section 14 of the Copyright Act. And as I said, it is a state-created monopoly to incentivize creators. But this monopoly is for a limited number of years. Okay, so one is, of course, the lifetime of the author in case of books, and a particular duration that we will discuss. But this, as I said, monopoly is always bad in any country. But this is to keep a balance between the uh, rights of the creators and, of course, the general public good. So anyone who contributes protectable expression is protected under the law. So as I said, the way today I'm talking to you, I mean, the lecture I'm delivering today is a protectable expression. Okay, and this is also protected by the law. These are some of the things which are covered under copyright protection. Of course, poetry, fiction, plays, movies, design. Sorry, the photos, paintings, choreography, music, and various kinds of design, sculptures. So everything is actually protected by this law, that is intellectual property. Now, let me just briefly tell you about the history of copyright. In the middle of 15th century, the idea of copyright actually emerged. And the history of American copyright law originated with the introduction of the printing press to England in the late 15th century. So what used to happen there in England, that uh, uh, the king actually wanted to keep the control of all publications. So he gave this right only to one company, that is called the Royal Company of Stationers, which was supposed to take rights to publish, take rights from creators to publish. And wherever it was seen that any other person is printing, then the copies, the administration used to burn the such copies. But the good thing in this was that like we have Delivery of Books Act of 1954, where we are supposed to, every publisher is supposed to submit copies of all the publications to 3 public libraries, including the National Library of Calcutta. Uh, so here also, the Royal Company of Stationers was supposed to deposit a copy of every book with the Oxford University Library under an agreement which was signed by Thomas Bodley in 1610. And Thomas Bodley was the librarian of Oxford University, and that's one reason why still University of Oxford's libraries are named after him. They are called Bodleian libraries. And in India, the history goes back to 1847, where the act was introduced during the British East India Company tenure. And then the Copyright Act of 1914 under the British Raj, which was similar to the Copyright Act of 1911 of the Great Britain. And now today what we see is Copyright Act of 1957. After 1957, there were a lot of amendments in different years, and these amendments are basically to accommodate newer things. Like when this act came, of course there was nothing included in it about electronic documents, about the exceptions which are available to physically challenged people or especially able people. So to accommodate newer things, every year, I mean, these 6 times, the amendments were made. So a lot of people, ask me whether registering, just a second, please. Yeah. So a lot of people ask that if registering copyright mandatory or adding the symbol, the C within circle is sufficient for protection under IPR laws. So, whether you put C or not, your work will get protected. And as I said, and as by definition given in the Copyright Act, any protectable expression is protected under the Copyright Act. But for the sake of safety or for the sake of prima facie evidence of your ownership, it is good practice to have this C when, which you generally put on the back side of the title page of any book, that which is called verso. So on every, back side of the title page, you see that C within circle is written either against the name of the author or against the name of the publisher. So basically this tells you that who owns the copyright, right? So actually, if it is written, say for example, if I want permission for using that copyrighted material, I should know whom I should approach, whether it is the author or the printer or the publisher or any other person. So that is why it is important that we have these C written in whatever creations we come out with. So Copyright Act 1957 stands for the legal rights exclusively given to the authors or creators of intellectual work. And I said, what is intellectual work? Creations of our mind. Copyright protects works of authorship, whether it is published or unpublished, in any tangible medium of expression like writing, music, art, computer software, film, etc. But here, the originality is, of course, very, very important. You just cannot get something copyrighted on something which is not yours. Then the copyright works in India enjoys same rights and privileges in other countries which are members of the Berne Convention. So, this Berne Convention, India joined this in 1928. And when any country joins the membership of Berne Convention, then they are supposed to respect the copyrights of all those people who are in different countries, and they are members of that Berne Convention. United States joined this convention quite late, that is in 1988. So, similarly, here the countries, the rights of people who live in other countries we are supposed to protect their rights too, whether it is published or unpublished. And these were some of the convention, which I thought I'll just tell you. The Paris Convention of 1883, and then Bonn Convention. And this is more important for us because it relates to author works, and then, of course, Universal Copyright Convention on copyright. So rest of the things are also important, but for us, these two are important. That is Bonn Convention and Universal Copyright Conventions. So let us talk of copyright duration now. So copyright subsists, remain in force for a definite period of time, as I earlier also said, and throughout, of course, the lifetime of the author and a term after the death of the author. So, and this term after the death of the author varies from country to country, but in India, what we see is that it is 60 years. So the lifetime of the author, and after that 60 years. So till this period, the work will remain under that person's copyright ownership, or he or she will be the owner as long as a person is alive, and after 60 years. Now the 60 years will start counting from the calendar year. So for example, if somebody passes away today, then from 1st January 2021, that for 60 years will start calculating. And in case of multiple authors, if there are 3 authors, then these 60 years will start calculating from the death of the last author. And if you want to see more on this particular issue, you can go to section 22 to 29 of the Copyright Act under chapter 5. And initially, when this Copyright Act was introduced, or you can say emerged, so the copyright duration was quite less. So it was, of course, lifetime of the author plus 14 years. And then it rose to 28 years, and then the number of years started increasing. And now if you see in United States, so it is lifetime of the author plus 70 years after his death. And India also, as I said, it is 60 years. And sometimes copyright lasts for long number of years, maybe sometimes over 100 years. And why it is? Because of course, the life expectancy, and then the definite period that I just told you. Now, the most important thing for all of us to understand is about the ownership. Who owns the copyright? So that is something which we perhaps need to understand very clearly. So author says, I'm the creator of the work, I'm the author. But employer says that, no, you did this work during the course of your employment here in my company or university, so I own the copyright. Publisher says that you have already transferred the copyright to me, so I own the copyright. But the government says, nothing doing, it is the government which holds the copyright, because these things are owned by the government. But for a librarian, irrespective of the ownership anybody might be having, whether it is author, employer, publisher, or state, the librarian has to make a fair judgment about the fair use, because he is, in the business of giving photocopies from journal, photocopies from books, etc. So for a librarian, it is important that he or she understands what is the fair use. And similarly, it becomes important for anybody in the academics to understand the nitty-gritties of fair use and copyright. So, for works which are conducted during the course of employment under a contract, employer holds the ownership. But having said that, say for example, I am working in Maulana Azad National University. Whatever I do for this university, for example, on the right hand side, you see a document picture. And this, the committee of 4 or 5 people, including myself, we did this. But can we say that it is, we hold the ownership, or we own the copyright of this document? We cannot, because the mandate was given to us by the university to prepare this document. So we do not hold the copyright of this particular document. But there are of course exceptions, like if I write articles, if I write book chapters, if I publish books, then I will be the owner of the copyright. Now, in case of sponsored research, they are treated differently. It all depends what is the agreement that you have signed with the sponsoring agency. So if you have said that the copyright will be vested with the sponsoring agency, then it's fine. Or if it is with you, then also, see, it depends on what you have signed. And then, as I said, all government's works are actually owned by government. Whatever ministry documents which you see on their website, they are owned by the government. But of course, we all can use it. Similarly, the artist of a photograph, of course, he owns the copyright, then painter owns the copyright, and so on and so forth. But if there are, for example, two or more authors, what happens? Who owns the copyright? Of course, all. But say if I have written a book and if I have taken a picture from someone to use in my book, then he in a way becomes co-author, and he or she may also claim the copyright. And if I start generating revenue from that particular book or document whichever I publish, so here, the co-author can always ask me that he also needs revenue from that. And the reason is because, there is no, sorry. In case there was an agreement between you and the second author, then it was perfectly fine. But in the absence of any such agreement, he automatically holds the ownership. Both of the authors will hold the ownership. So it is important that, whenever we do such things, it is better to have everything in black and white. So now let us understand what are the rights of any creator. So the rights are to reproduce the copyrighted works, number one. Number two, to distribute copies of works to public, whether in the classroom, or you want to put it for sale or rent, or if you want to transfer the ownership, all those things you can do as a creator. And then you can also prepare derivative works of the copyrighted material. So what are derivative works? Say for example, if you have published edition 2 and you are going for third edition or fourth edition, those are derivative works. Similarly, if you want to convert a play into movie or a journal article into a book chapter, all those things you can do. You have all the rights given to you in the Copyright Act. And then to perform the copyrighted works like dance, music, performance, etc. And then to display the copyrighted works. And then as a creator or as the copyright owner, I can also grant permission to different people, and those permissions could be exclusive or non-exclusive. So what is exclusive permission? I already told you. When the permission is given to only one person, say for example, if I'm coming out with a publication, I just want only one vendor to market that or to distribute those books. But if I give non-exclusive rights, so for example, in our libraries, we keep subscribing to a lot of databases from different publishers, and those publishers actually grant us non-exclusive license. We do not, just because we have purchased a database, we do not become owner of that product. We only have the right of its use in a non-exclusive manner, because these rights are given to others also. So, and as I said earlier also, copyright is applicable to both published and unpublished works. I think it is very important for all of us to understand what is the difference between copyright infringement and plagiarism. A lot of people get confused, so I thought I just prepare a slide and make a clear distinction between these two. So copyright infringement is using someone else's work without obtaining their permission. Okay, whereas plagiarism means when you use something in your document and you do not acknowledge the source. So that is plagiarism. Now, in case of copyright infringement, affected party lodges the complaint with the court of law. And in case of plagiarism, anybody can go to the integrity panel or head of the institution and make this complaint about plagiarism. Then copyright infringement cases are, as I said, taken up by the court of law, whereas the plagiarism cases are handled by Departmental Academic Integrity Panel and Institutional Academic Integrity Panel, as per the UGC regulation of 2018, what we discussed in the first half of today. So copyright comes under criminal law system, and the person infringing the copyrights can be convicted, imprisonment or and even compensation. But in extreme cases of plagiarism, a person can be terminated. So that is the, as per, of course, UGC regulation. So this is the difference between these two. And when we see, today's digital teaching, then copyright has become more complex. Respecting copyright sometimes becomes extremely difficult because of the electronic or digital classrooms. And we will discuss these things in detail. So before I discuss those things, let me just first tell you how do I decide about using any copyrighted material. Okay, so I think that that clarity has to come in us, that how do we actually decide. So before we understand, or before I tell you how shall we decide about using a copyrighted material for my work, let me just tell you the definitions or some discussion on public domain, exceptions, licensing, permissions, and fair use. So what is public domain? I was telling you in the morning that everything which is on the internet cannot be called as things in public domain. So public domain refers to creative works that are not protected under copyright and any other form of IPR laws. The public owns such works, not an individual creator. No permission is needed to use such works which are in the public domain, and are not copyrighted. And when work falls in public domain, when the copyright term expires, and as I said, the lifetime of the author and 60 years, then the copyright owner puts his or her own work in the public domain. So for example, if I create a video today and I put it in public domain with the Creative Commons licenses or any other licenses which actually allow you to use it freely, so that is those things will be in public domain. And when I put such works in public domain, those works are called dedicated works, and these things cannot be revoked. Once I have put something on public domain, I cannot just go back and say, now these are copyrighted. And the third thing is the work is not copyrighted when, like for example, title of books, facts, ideas, slogans, or short phrases. So these things cannot be copyrighted. So this is what public domain content means. You must be using a lot of pictures from Google images, etc., without realizing that there can be some copyright on these images. So what we should do always is that when we search for such images, so when we go to this particular thing that's called tools, and here under usage right, what you see here is that there are Creative Commons licenses and commercial other licenses. So what is Creative Commons licenses? Basically these are licenses where you are allowed to use different kinds of copyrighted material in different manner that we are going to discuss. So what I suggest that always use this Creative Commons license, so that tomorrow nobody says that you have violated the Copyright Act. Now similarly, if you go to Flickr's website, so there are a lot of common creative images which you get. So this is what it says, creative. There are other commercial licenses also, but you need to select only Creative Commons licenses pictures. Now similarly, if you want to adopt some video, or if you want to use a particular clip from a video to show in your classroom, then you make sure that these are Creative Commons videos. So what are those? On the top left hand side, you see there is a button called filter. So if you go to filter, here you can always filter it by Creative Commons. And there are other filters also which you see here. But for us, for this, in the context of copyright, this Creative Commons is important. Now, similarly, I came across a situation where somebody called me from one of the universities in Bombay, and he said that there's a complaint from someone who was owning the copyright of a music, that a faculty member of particular university has violated the copyright. So it is important that even for music which you want to put in our videos for the sake of making videos for our students, we must make sure that we use Creative Commons licenses or video musics. And then if you want to just go into the details of what is this Creative Commons, let me just briefly tell you what these licenses mean. So if you go to this Creative Commons website, you will find definition of all these licenses. So what this licenses says here, it says attribution CC BY. So what does it mean? It means that this license lets others distribute, remix, adapt, and build upon your work, even commercially. Okay, as long as they credit you for the original creation. That is number one. And here, here you see there is an additional thing, SA. So what does this mean? This means that this license lets others remix, adapt, and build upon your work, even for commercial purposes, as long as they credit you and license their own creations under the identical terms. So this is additional things which they should license that in the identical terms. Similarly, these things can be used even for for non-commercial purposes. Okay. And then the next, so here is the website where you can go and see what you can what each licenses means. There are about 10-15 licenses, if I correctly remember. Now, after that, what we discussed about public domain, let me also now talk to you about exceptions of copyright. So what does exceptions mean? And let us understand what is classroom exception. So, in a face-to-face classroom, there is no problem using any kind of copyrighted material because it is a physical classroom, provided, that organization where you are working is not for profit organization, and the work should have been lawfully made, or you should not have any reason to believe that they have been obtained or made unlawfully. And students must be sensitized about these copyright issues. And in case you are going to record the proceedings of a classroom, make sure that you have necessary permission from your students, that they allow you to use the recording, to record them. And also, you must sensitize the students that they should not distribute such recording, because if they distribute that, it will be the violation of copyright. And this particular exception of the copyright is only in the context of physical classroom, this particular thing. Now, as I said, in online classes, it becomes more complex to adhere to the copyright norms. So, as long as there is a close registered group of students where you are delivering your lecture, there's no problem, in using copyrighted material. But here the problem is, in case of physical classroom, you have no problem in distributing, say, maybe an article to all the students, provided you sensitize them about non-distribution of such material. But in case of online classroom, you simply cannot show the complete article in the online classroom. What you can do is, in such cases, is that you simply give links of those websites from where such document can be downloaded. And the amount of material used in a physical classroom has all the exception which may not be true in an online classroom. So that, I think, we all have to understand. And wherever required, give necessary acknowledgement. We have to be very, very careful when we do when we conduct online classes. The university where you're working, or the institution where you're working, should have a mechanism wherein proper awareness is made about that. And also the university creates an environment which prevents unauthorized access and distribution of material which are discussed in a particular online classroom. And students should also be told that they should not interfere in the technology. So what suggestions I can give you is that maybe you can, in the log files, you can stream live so that they are not able to download. You disable the right click, and you can use low resolution pictures so that they are not able to reuse it. So all these things you can do. And when it comes to the use of subscribed resources, say for example, if I want to use any of the resources which Manu is subscribing, then I will have to make sure that I understand the licenses agreement which the librarian signs with the publisher. And when we subscribe to resources, we always sign an agreement with the publisher. So that we also have to be careful about. And then there are exceptions in the Copyright Act, Indian Copyright Act, for libraries also. So libraries should be for not for profit libraries. And as a library, with regard to the exception, I am permitted only to digitize things whatever I have in my library, but I'm not supposed to distribute this. So what does it basically mean is that I should make a necessary arrangement or set necessary mechanism in place wherein the things which I digitize and which are copyrighted are accessible to our users only within the premises of the library. In fact, I should also avoid putting it on the university's intranet. And if the another additional exception about library is that we can make photocopies from books or chapters, but provided such photocopy is not for profit. It should not happen that I start making money out of copyright. And libraries also are supposed to actually sensitize people about the copyright. And in 2012 amendment of the Copyright Act, what we see that there are a lot of exceptions for disabled people or physically challenged people. So what you can do in such cases is that you can even convert a textbook into speech and give it to especially able people who cannot see or who have visual impairment. So then the second last thing I think is the licensing. We have to understand this licensing properly, because as I said, when we subscribe to resources, we sign agreement with publishers where we are allowed for something and we are not allowed for something. I may be allowed to download a particular portion of a book in one batch and not maybe 10, 20%, 30%, or 40%. In some cases, I may be allowed to access my library resources remotely from our houses or wherever we are. But in some cases, it may not be allowed. Now, similarly, there are concepts like DRM, no DRM. DRM is basically digital rights management. So we should also see, we can try to, purchase only those books which have no DRM. And these licensing issue is more relevant to librarians, not to faculty members. But having said that, whenever you want to use any resource which your library has, I think there is no harm in contacting the librarian and discuss and understand the licensing agreements that one has signed with the publisher. And then this is the second last, in fact, permissions. So if I want to use a copyrighted material, I must seek necessary permission from the copyright owner. I may have to write in an email, because now Information Technology Act of 2000 allows us to or recognizes these things as evidence. So we can always send emails to copyright owners to seek their permission for using their copyrighted material. But when we seek permission, we must make sure that we have complete clarity on the scope of permission that we need. I may need a picture to use in my book or maybe on the cover page. So it is important to tell the copyright owner that where you want to use the picture. Because if you want to use in the book, he or she may not have any problem. But in case you want to make it or put it on the cover, he or she may charge something from you. And make sure that, to try to identify who is the copyright owner. Sometimes it is very difficult. Sometimes, they will not even respond, but they are not obliged to respond. It is we who need to use copyrighted material that we follow up again and again with people who own copyright. And this is the last thing which I wanted to tell you is, of course, the fair use. So what is fair use? So fair use is a legal doctrine which allows a person to make limited use of copyrighted work without the permission of the owner. So, and we keep doing it every day. We, when we write articles, we give citation, we provide references, and we keep doing it. So this is called fair use. So there are a lot of other kinds of fair use also in the context of, libraries, which I'm not going to discuss. So now I assume that we have some understanding of these 5 things, that is public domain, exceptions, licensing, permissions, and fair use. Now I ask the same questions or put up the same questions before you as to how do I decide about using any copyrighted material. So since, as I said, we have clarity on these 5 areas, so what we can do is, these are the 6 things which I have listed out here. So, if you want to use any work, so first you assess where the work is, whether the work is copyrighted or not. In case it is copyrighted, just check if there is any exceptions allowed in the Copyright Act. And the exception, as I said, for physically challenged people, for libraries, for physical classroom, for online classrooms, etc. And then, if you find that there are no exception available in Copyright Act, then you can check, if the material is protected under any license. And if you are not able to get any satisfactory answer, then probably you explore using or making use of that content as fair use. And then, if you find that, you cannot make fair use of that particular thing, then check whether you need permission. And as I said, taking permission is difficult and it is very cumbersome, but you have to do that. Otherwise, you may violate the copyright norms. And once, even if you again fail to get permission, once again explore the possibility of fair use. So this is how, I decide about using a copyrighted material, okay, which I just said in the previous slide. So if we work on these 6 areas, possibly we'll be able to make sure how to use a copyrighted material. On the Columbia University website, I got this checklist, very interesting checklist, which actually tells me how I should decide. And they have listed out 4 parameters. What is the purpose of using a copyrighted material? What is the nature of material I want to use, which is copyrighted, of course? What is the amount of use, and what will be the effect if I use that material? Effect on the copyright holder or copyright owner. So let us take one by one. First is purpose. So on the left hand side, what you see here is these things favor fair use, and these things do not favor or go against the fair use. So if it is for teaching, research, scholarship, or for non-profit education institution, it is if you want to use, if you want to write a criticism or comment or make a reporting in the newspaper, etc., then it is perfectly fine. There is no problem. But if it is for commercial activity, if you are earning some money from it, if it is for the purpose of entertainment, or if it is bad faith behavior, or if you want to deny the credit to the original author, then it will go against the fair use. Now, on the left-hand side, we also see that transformative or productive use. Now, that is also considered to be fair use, but we have to understand what that transformative or productive use is. Now, say, for example, there is a website called Hathi Trust, hathitrust.com, where you will find a large number of books which are available to you for access. And that website actually has taken things from various libraries in the West, and they have put up proper catalog. So whatever is out of copyright, they have given full text access, and whatever is copyright, so they have just abstract or table of content, etc. So that is actually transformative use, because I am not infringing the copyright of others. I am simply, collating things and providing at one place for the convenience of the user. So that is transformative use. And then, parody. So what is parody? If there is a song, if you want to change that song into something else for some purpose, that may not actually substitute the original product, so that is also allowed. Similarly, as long as the access of copyrighted material is restricted, there is no problem. So this was about purpose. Then we come to the next and second, that is nature of material being used. So if it is published material, then there's no problem. But if it is unpublished, then probably I think we need to think twice before using the copyrighted material. We may need permissions and so on. So if it is factual or non-fictional based information or material, there is no problem. But if it is highly creative work like art, music, novels, etc., then there is a problem, and it actually oppose the fair use. So if it is fiction, of course, fiction is involves a lot of creativity. So there, you cannot say that you want to make fair use. So this was about nature of material being used, and then comes the amount of use. So as long as the quantity is small, there is no problem. Okay, and as I said, when I first told you about fair use, is a doctrine, legal doctrine, which allows to use a limited portion of copyrighted material. So if the quantity is small, there is no problem. And if the portion used is not central or significant. Now, what does it mean? So, for example, you are not copying or not taking anything, but you are taking the central idea of a particular work to your work. So that will be the copyright violation, and it will not, of course, favor the fair use. And of course, as I said, as long as it is for education research purpose, there is no problem. And then what will be the impact or effect of using of this copyrighted material? So these are on the left hand side, you see that, as long as user owns lawfully acquired or purchased copy of the original work, there is no problem. But, it should not actually impact the sale of copyrighted material. Okay. It should not significantly impact the revenue of the person who owns the copyright. So there are, a lot of things which you see on the screen. And this actually makes our life easy to understand how we can use or make fair use of the content. I'm sure that you got some, if not complete clarity, then some clarity about making fair use of copyrighted material. I'm sure you must be aware of this Delhi University photocopy case and what happened in this. So I told you that, as long as the quantity of copyrighted use, when you use a small quantity of copyrighted material, it is fair use. But this particular judgment in this particular case, changed the complete definition of this. The quantity. The interpretation of quantity is completely different. There was no regard for this quantity. So that, and what that case was, in case you are not aware of that, let me just briefly tell you. What happened in 2012, that Oxford University Press and few other publishers, they approached the High Court, and they sought a permanent injunction against Rameshwari Photocopy Services, which was operating in the premises of University of Delhi. And this case was against the University of Delhi also. And the publisher said, we are losing out on revenue, so you have to make sure that this Rameshwari photocopy is stopped, is given an order so that this photocopying is stopped. And the lawsuit against Rameshwari Photocopy Service and Delhi University accused the defendants of infringing the copyrights of the plaintiffs in their publications by photocopying, reproduction, and distribution of copies of plaintiffs' publications on large scale and circulating the same. So what Rameshwari Photocopy was doing was that it was photocopying from different books and making a separate book. So trying to make a course pack out of various books. But the owner of the copyright said we are not infringing any copyright. There's no infringement. And then a lot of authors from University of Delhi who were actually authors in those publishers' books, so they also became party to this whole affair, and they also started supporting the uh, Rameshwari photocopy shop. And then they wrote a letter also to the court saying that this perfectly fine. The court should take a liberal view on that. And in the landmark judgment, delivered by Justice Endlaw in 2016, the court passed ruling against the publisher and allowed Rameshwari photocopy services to continue its business. And as I said, there was complete disregard of the quantity when in the context of fair use. And then these publishers went to the higher court, but after some time they withdrew their case from the higher court, and they said that they did not want to engage into any kind of legal battle with their own stakeholders. And there was a very interesting editorial which was published in the Indian Express, and it said that ruling in Delhi University copyright case reflects the inability of Indian courts to integrate legal outcomes with robust business models. And this particular editorial criticized the judgment, and if you get time, please read it. So, the judgment, as I said, even ignored the quantity. So one can always, photocopy books and distribute, citing the Delhi High Court judgment. But as the land of the law of the land is Supreme Court. But since there was no, it has not been nullified by any of these states, so this law is applicable, and we can do all those things which uh, I don't want to say it is copyright violation, but we can make photocopies from books. But in my view, academic institutions should interpret the judgment in the right spirit and should not consider the court judgment as a license to violate the prevalent copyright and intellectual property norms. And being in the same fraternity, I think we must respect the IPR of creators, because you may also be creator, I may also be a creator. So uh, so there was another case, as I said, against Hathi Trust about transformative use. So there was an order which was again in favor of this Hathi Trust, because the court said, the international court said, the US court said that it is not a substitute. It is not a substitute to the product which is there in the market. And this, today I was just in the morning after our class, I was looking at this particular report, which actually, where it says publishers are taking the internet to court. And what happened recently, I think in March or April, that HarperCollins and Wiley filed a lawsuit against the Internet Archive, alleging mass copyright infringement. So what these people were doing actually, because of COVID, that they were giving access to a lot of books which were of course copyrighted, and they were making full access. They were giving full access to all those people who were there on the internet. So now this copyright is slated to be heard in the year 2021, and let us see what the judgment comes. But what we generally see is that courts are very liberal about these things. And in this article, what I saw, a very interesting line, which says publishers are stewards of the right of authors to make a fair living. Librarians are stewards of cultural prosperity, where we are supposed to archive things for future use. So in conclusion, I would like to say is that it is very important for all of us to understand fair use, so that we do not violate copyright norms. And we must read the fine prints of licensing agreement. If we do not know, maybe the librarian is the person whom we should talk to about these things. And we should always keep our all permissions very safe, because as I said, that copyright sometimes may last for over 100 years. So we must respect IPR. We should try to publish in open access platforms, and we must also promote the cause of Creative Commons licensing. So with these words, let me just thank you once again. And I hope it was of some use. So thank you. And if there are any questions, I'll be happy to take up, and let us see whether I'm able to answer your questions or not. Thank you.
Thank you, sir, for a very important talk on intellectual property rights. And I suppose the participants have understood the implications of infringing on them, understanding what copyright is, and so on. So if there are any questions from participants, they are requested to ask either in the chat window, or you can unmute yourself and ask. It is essential to discuss intellectual property rights when we are talking about research methodology, publications, and so on. It's a very much part of research and so on. So you have to be very clear about it. And if there are any doubts, you can ask Dr. Akhtar Parvez now or any time later.
Yes.
Any comments? So you wanted to speak about Mendeley or
Yes.
demonstrate it. Would you like to do that? To use this time, we have some time with us.
But there are no questions.
There is one from Dr. Surya Kant.
Hello, sir. Good evening, sir. Good evening, sir.
Yeah, good evening, madam. Good evening.
Myself, Dr. Prashanti from Mahatma Gandhi University. Sir, very nice and informative lecture. Sir, I request you to know how much percentage of plagiarism is in like thesis part or in other journals, sir. I know it all depends upon the university wise, but minimum standards, sir, at least to maintain.
So you asked me what is the percentage of plagiarism that is allowed. So it is 0. It is the similarity which is 10%. Okay.
Sir.
So similarity is allowed up to 10%. But having said that, though UGC regulation says that 10% is no problem, but it should not happen that 10% actually is the central idea of somebody else's work. Okay. So, but yes, for all practical purposes, it is 10%. And you said that every university has different norm. It's not like that. Now, after this UGC regulation of 2018, everybody is supposed to follow that norm of 10%. And then your question is, the publishers, how much they accept. So it depends from publishers to publish. There are publishers who say 5%, there are publishers who say 10%, then 15%, 20%. So it depends from publishers to publishers. But I think what is the important thing which we all should understand is, why do we leave any scope for any similarity or plagiarism? So what we can do is, whenever we put any document into, of course, before sending any of our paper for publication, we must check these papers for similarity and then make necessary improvement. So after those improvement is done, then we should send to the publishers, because anyway publishers will also check for their in their softwares. But so for example, there is a publisher who says I will accept a similarity up to 25%, and you get your article published. But what happens about the regulation of 2018, which says it is only 10%? So yes. Anybody anytime can accuse you of having plagiarized, saying that it is 10% and yours is 25%. So, and you cannot take the excuse of saying that because that publisher allowed us to have 25%, that is why we did. So it is important that prior to 2018, before this regulation was notified, I mean, there were different norms, and I think every university should respect that. But after 2018, there is complete clarity on the issue. So it cannot be more than 10%. In fact, I have seen a lot of people, 1 or 2 people from our own university, that when the similarity was just 8%, they still worked on that and they brought it down to almost 2 to 3%. So I think, I hope I could answer your question, madam.
Yes, sir. Yes, sir. Thank you very much. Sir, is it possible to self-cite in our thesis part, sir?
Yeah, if you want to self-cite some article of yours in thesis, there is no problem.
Okay, sir.
Yeah, there's no problem. But one is, of course, it has to be reasonable number of citations.
Yes, sir.
Not just from self-citation, but otherwise also there should be reasonable citations in any of your work. And then there
Thank you,
is
sir.
another.
Thank you.
Thank you, madam. Thank you. The other question, sir, can we go for having copyright for all published articles or only for patented work? For articles, it is the publisher who actually will ensure about this copyright issue, so you don't need to bother. But when you give your work to publisher, so what are the copyright terms and conditions that you negotiate with them? Now, what happens in traditional publishing where, now I'm not talking of open access publishing. In open access publishing, you publish in open access platform and everybody can see that document. Everybody can read that. People can cite from that. There's no problem. But when it comes to a traditional mode of publishing where you publish an article maybe through Elsevier or Emerald or many other publishers, so there what happens that once you give your article to them, so the copyright then is with them. And even if you want to download that article, you also will need to pay for that article. And if your university wants to put that article in its repository, publisher will not allow because the copyright is with publisher. So it is better that, whenever we negotiate with the publisher for publishing our articles, we must make sure that they should allow the author to use that document, of course, to make that article part of a repository, and also, to distribute it distribute it for the sake of fair use. So I think it all depends how you negotiate with the publishers about your rights in the context of copyright. So I think I could answer Dr. Babu Rao's question. Then there is another thank you. Okay, so there are some thank you message. So thank you very much. Dear sir, in terms of a student point of view, how this question is from Mr. Arun Kumar Banagar, and it says that, dear sir, in terms of student point of view, how one can judge that a textbook is quality book. For example, for journals, we check their impact factors. Similarly, for textbooks, yes, it's a good question. Since we all are in the business of publishing or reading books, etc. So when we read books, to a large extent, we come to know the quality of this. Number one. Number two, if we have any confusion about this, probably we can always contact our senior faculty members and check how is this particular author. Can this book be recommended, or the textbook be recommended for further readings? You also need to understand who are the publishers who are publishing such books. So if it's a new publisher, probably you should prefer books of reputed publishers over the new publishers. But at the same time, I'm not saying that new publishers cannot be good publishers. So I think it is all your judgment. If you are satisfied with the content of a book, only then you can ask your students to refer to that book. So I think that the clarity has to be there, and probably you are the best judge. And when people recommend for books, which libraries are supposed to purchase. So that time also the faculty must see the quality of those publications, and not just the quality. They also should see who all are writing in those books. Similarly, in journals also, if you are doubtful about any particular journal content, then you see who all are contributing articles in that journal. So you will find if you find some very good people, then of course it's perfectly fine. And as I said, you can always take help from your senior colleagues to have complete clarity on the quality. And these things you learn by experience. I'm sure Professor Hassan will agree with me that as you spend more time in a particular field, you keep learning things, and there is no substitute to the experience that generally we get at our workplace, etc. So I think I hope I could answer your question. So any other question? If any other question, please ask me. In the meantime, I will see the chat box also. So you can unmute and ask if there is any question. Okay, so while visiting any, okay, so Farooq Hussain Inamdar Sahab has asked one question. While visiting any places, Google Map asks to help them by uploading pictures. Will that pictures come under the copyright? While visiting any places, Google Map asks to help them by uploading pictures. No, those things, uh, uh, when Google actually is, what I understand is that uh, uh, when we go anywhere, then Google Map actually gives us direction, places, etc. So those things actually are, I would say, that is fair use. Okay, so whether it is Google, and I'm sure Google must have made necessary arrangement with that. And of course, I feel it is fair use. There should not be any problem with regard to the Google Map. In my opinion, I don't think so. I consider that as fair use. So hope I could answer your question, Inamdar sir. Okay, any other question? Yeah, any other question if you have, please feel free to ask me. Because copyright is something which is very, very important, which okay, thank you, Farooq sir. Thank you.
So maybe you can comment on the from the resources on the net. There are certain pictures and which are available, which are you can reproduce for academic activity. There are copyright rules, and that can be checked from.
Right, sir. Right, sir. I'll just
comment on that.
Let me just share my screen. Okay, sir. So, for example, if I go to Google here, okay, and say if I want to use any picture of library. So if I say library, and if I go to images, okay, so there are a lot of images I get here. So can I use this image? Okay, so usually the license is always given here. Like images may be subject to copyright, and here you can see all the copyright, what is permissible and what is not permissible. The other option is that when you search for these images, you filter it by this is the tools button. So you filter it by usage rights. So you filter, one is commercial and other licenses, and the first one is Creative Commons licenses. So Creative Commons licenses are basically those licenses where the usage is very quite liberal. So for example, this particular thing, okay, this image whether I can use it or not, that also let me just licensing details. Okay, here you see licensing details. So if you go there, so you go to this particular website and it says attribution by CC. Okay, so which means you are free to use it, provided as long as you give acknowledgement. That is one. Now similarly, if say for example I go to Flickr, I already told you, but let me just once again tell you. Okay, so Flickr, I suggest that, if you want to use some images, so you should always use Flickr website, because here I always find that you will find excellent images. Okay, bright images here you will find. And let me just, okay, so okay, just a second, please. So if I say colorful photos, then okay, I think I will have to log in, so I do not want to log in now. Though I have a user ID and password, so you can sign up for free, and here again you can select all the images which are Creative Commons, which have Creative Commons licenses. Now again, if I just want to show YouTube videos, and on YouTube, in our online classes, we sometimes use some clips from some videos. Say, if I say stock verification in library. Okay, so here what I see is that I get a lot of videos here. Okay, so I get a lot of videos, but can I use all the videos, or can I use the clips from all these videos? I am not sure. So what I will do, I will just go to filter, and I will choose only Creative Commons licenses videos. And now there are different videos. So one is of course my video on stock verification. So if I go there in this particular video, okay, shows me here that I'll just, okay. So here it is an, I have prepared this under Creative Commons licenses. So then it says here Creative Commons attribution license. So reuse allowed. So which means you can you can adapt this video, you can reuse, you can distribute this video, anything you can do with this video, because this video has been created under this license, that is Creative Commons license. And every image, more or less every image will have licensing terms and conditions there. So I think that is, sir, hope I could explain what was expected from me.
That's, yeah.
Okay, similarly, similarly, I was saying about Hathi Trust website, which is again, or I will rather go to open access journals directory. This is the website of open access journals, and there are more than 15,000 journals listed here, and you can use these text without any problem with regard to the copyright or any such thing. And you can also contribute your article on this platform with different publishers. And similarly, there is a website called Directory of Open Access Books, where there are thousands of books which are available free of cost in full text. And here, say for example, let me just search by mathematics. So if I want to search, there are 661 journals on this area. Okay, so of course these are different languages, so you can always filter it by language. I'm sure somewhere or the other here must be given. So you can always filter it by language. Okay, so search all. Okay, so I mean, this is how, and here also you see on the right hand side this Creative Commons license symbol is there, so that can be freely used. So I think we all need to do is probably we need to spend some more time on these issues, and then maybe we can have complete clarity. We should know all the open education resources, if not all, at least those education resources, open education resources which are available in your own area. so that we are able to compensate for things which we cannot access, because some of the things are very, very expensive. So in such cases, we should see how we can make best use of open access material available in the public domain. Yes, sir.
Thank you. Thank you, sir. So do we have time, or we are running? We have 10 minutes more,
Yes.
but if there are no questions, maybe we can stop. You had a heavy day. Pictures in a day are too much. So thank you, sir, for a wonderful presentation. Mehrun Nisha Begum says, and Dr. Surya Kant Babu Rao and Farooq Hussain Inamdar all are thanking you for a wonderful session. So thank you, sir. So if there are no more questions, let's thank Dr. Akhtar Parvez for patiently taking us through 2 sessions, one on plagiarism, where he discussed the copyright issues and how to check for plagiarisms, the rules required, and so on. And in the afternoon session, he discussed the important issue of intellectual property rights. So with this, we'll end today's session, and we will meet tomorrow at 10. But let me please remind you that